Professor Nam Yong Lee's column, long, Korea Must Restore and Fully Settle, in a National Ledger, the unpaid wages and dignity of 280,000 forced labor victims from the Japanese colonial era. The first task is to define, without ambiguity, who the stakeholders in this problem are. The first stakeholder group is the Korean workers, who were forcibly mobilized against their will under the Japanese state power and wartime munition system during the colonial period, and their bereaved families. The second is the government of the Republic of Korea, which designed and executed the 1965 framework of the Korea-Japan Claims Agreement. The third is the Japanese government and Japanese companies that were involved in mobilization at the time and thereafter. The fourth is the National Archives of Korea and the relevant administrative bodies of the Republic of Korea, which produce and verify national records, and at the same time serve as the executing institutions for victim relief. The relationship among these stakeholder groups can be summarized in one line. The moment a victim's private claim for unpaid wages and damages is absorbed into an interstate settlement structure, the state has in effect promised an internal settlement to the victim. If that internal settlement is not fully implemented through ledgers and institutions, the state ends up diverting the victim's rights as an implicit collateral for national growth projects. The essence of this issue is not anti-Japanese sentiment, but a failure of national responsibility in accounting and settlement. The National Archives of Korea has organized and disclosed personal records related to wartime mobilization under the title Roster of Persons Mobilized Under Japanese Rule, Wayongsi Pijingyongja Myongbu, explaining that across 20 volumes it contains personal information on approximately 285,771 individuals. This figure is not an estimate, but a lower bound of the victim population that is at least identifiable through records. If the state is to speak of settlement, it must begin not with emotion, but with an identifiable ledger like this roster. The core of a forced labor ledger is identification and deduplication. Identifying victims based on national records is not an event of counting names. The fields in a person roster become the keys that determine an individual's legal status. Only when name, date of birth, place of origin, form of mobilization, destination, whether the person died or returned, and whether unpaid wages exist are linked, can claim eligibility be determined. Therefore, the state must first standardize records, eliminate collisions among people with the same name, and raise identification accuracy by connecting lineages through family relationship certificates and deregistered family registers. After identification, the state must conduct a precise analysis of what was not paid. Harm from forced mobilization is not a single block. It layers unpaid wages, unrecovered property rights such as deposits, bonds and insurance proceeds, industrial accidents, injuries and disabilities, death and disappearance, and psychological harm arising from inhumane and unlawful acts. Yet Korea's historical compensation framework treated these layers narrowly, and especially in early reporting and compensation designs, it operated by limiting the eligible scope largely to those who died before August 15, 1945. Today's redesign must therefore move away from a ledger that settles only the dead and become a ledger that tracks unpaid wages and unresolved rights, including survivors. Record-based identification is possible and fully feasible technically. What is needed is solely the political resolve of the government of the Republic of Korea and the President. The 1965 funds were an external settlement, while the internal settlement remained incomplete. The 1965 Korea-Japan Claims Agreement specified the framework for economic cooperation funds provided by Japan, commonly cited as a core structure of USD 300 million in grants and USD 200 million in loans. These funds were not compensation automatically paid to individuals, but entered a structure in which the state received and managed them. At that moment, the state assumed internal settlement responsibility for victims. The state created laws and institutions for operating the funds, and the legal system hardened in the direction that grant funds would be used for projects contributing to economic development, while loan funds would be used to expand key industries and social infrastructure. The problem is not the growth strategy itself. The problem is that while pursuing a growth strategy, the state failed to implement the internal settlement of victims' rights sufficiently in terms of both speed and scope. Supreme Court precedent specifically Zhang how the domestic legal system moved from the claims agreement toward reporting and compensation, stating that by June 30th, 1977, compensation totaling 9,887,693,001 was paid for 83,519 cases, and that within this, 8,552 cases involving the deaths of mobilized persons were paid at 300,001 per person. Here, the central question of state responsibility is born. Given the scale and layers of harm, was that compensation design and execution truly a settlement, or was it only a partial payment? When viewed numerically, the internal settlement gap becomes even clearer. The figure of 280,000 is a conservative framing of the problem. Even the National Archives' public description shows that several 100,000 names are captured in the mobilized person roster. For example, if the record identifiable set is taken as 285,771 people and only the 1965 grant of USD 300 million is assumed to be victim settlement resources, the principal allocation per person is about USD 1,050. This number is merely a lower bound of what should have been paid then, and it excludes wages, damages, and restoration costs. Now consider compounding. If the 1965 USD 300 million is compounded over 60 years to 2025 at annual rates of 3%, 5%, and 7%, it becomes approximately USD 1.77 billion, USD 5.60 billion, and USD 17.38 billion, respectively. Under the same method, USD 500 million becomes approximately USD 2.95 billion, USD 9.34 billion, and USD 28.97 billion, respectively. Dividing by 285,771 people yields a per-person reference amount of about USD 19,609 under the 5% assumption and about USD 60,932 under the 7% assumption. This is not asserted as the one true answer, but as a measurement showing how large the gap becomes when long unsettled rights are restored by the time value of money. By contrast, the fact that the 1970s compensation system paid 300,001 per deceased mobilized person is a slice of what the state officially recognized. This gap is not evidence of individual greed, but evidence that the design bandwidth of the system was too narrow. A national settlement cannot end with formal payment back then. It must withstand the question of whether it can be recalculated and settled in today's value. International standards combine the prohibition of forced labor with effective remedies. Forced labor has long been treated as prohibited under the core norms of the International Labour Organization, ILO, within a framework that places obligations on member states to suppress forced or compulsory labor. What matters here is not declaration, but execution. Once harm is identified, remedy must be designed not as procedurally possible, but as actually receivable. The UN Basic Principles and Guidelines on the right to a remedy and reparation point toward a framework in which victims have the right to effective remedies, and states implement recovery through measures such as compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Applied to forced mobilization, this principle means the state must not prolong disputes but bind record, recognition, payment and settlement into one flow so that recovery appears in the victim's life as restored cash flow. Even where historical reparations are not perfect, advanced countries share common traits. They confirm victim identification through state records, standardize payments, build sustainable fund structures rather than political bargaining, and above all evolve toward execution before it is too late. If Korea is to move toward an advanced country model in this matter, it must elevate its operating model to an international level, not through emotional escalation, but through institutional design. Korea's payment framework exists, but a closed door remains. The legal framework established in 2007 concerning support for overseas victims of wartime mobilization before and after the Pacific War provided categories such as condolence payments for victims and support payments for unpaid wages, and it guided standards such as a condolence payment of 20 million won for deaths and disappearances, and support for unpaid wages calculated by converting 1 yen at 2001. The Ministry of the Interior and Safety's guidance further states that applications for such payments were accepted and processed through June 30, 2014, and that it currently performs tasks such as redeliberation based on litigation outcomes and the payment of reserved amounts. This is the hard reality. Even if a person is identifiable in records, when the application window is closed, the right remains only on paper. What is needed now is twofold. One is rigorous practical action that pushes every possible route within existing systems to the end. The other is a legislative and policy prescription that reopens the closed portions of the system. In a separate track, the supporting foundation for victims of forced mobilization for Japanese imperialism operates by issuing annual notices for bereaved family welfare support programs and accepting applications. This is not identical in character to court-awarded payments or unpaid wage settlement, but it is practically important as a living window that connects official recognition with support. As a sample case, a settlement roadmap is proposed for Oki-Soon Lee, deceased, a forced labor victim. The first step is record-based identification. In the National Archives roster of persons mobilized under Japanese rule, it is necessary to identify the same individual by cross-checking the name Oki-Soon Lee, birth-related information, clues about place of origin, and clues pointing to the Osaka arsenal as the presumed destination. The National Archives' disclosure of the roster is precisely what makes this practical work possible. The second step is to split types of rights. Forced labor at the Osaka arsenal is likely to involve unpaid wages, and if violence, confinement, or discrimination occurred in the mobilization process, tort damages, psychological harm can be asserted separately, regardless of which track is pursued. An evidentiary bundle is required that links national records, family relationship documents, proof of death, and proof of mobilization. The third step is to confirm domestic payment history. It is necessary to verify through administrative records whether the person was ever reported or compensated under past domestic systems, or was ever determined to be an unpaid wage victim. The relevant government support unit announces that it handles the analysis of forced mobilization records and civil petitions, and discloses its contact information. The fourth step is to act by distinguishing between open doors and closed doors. After the 2014 deadline, new applications are structurally difficult, and strategies must assume that only exceptional routes remain, such as redeliberation, reserved amounts, and litigation-linked procedures. At the same time, annually open support windows, such as the Foundation's bereaved family welfare notices, should be used immediately. A prescription is offered for how the Korean government should settle this matter. First, the unit of settlement must change. It is not the total sum, but the individual ledger. Centering on the National Archives rosters and combining Japanese side materials with domestic family record data, the state must create individual settlement accounts, accumulating unpaid wages, property rights, injuries, death, and psychological harm as separate account items. Second, the payment model should be designed as rapid payment plus ex-post settlement. Effective remedy under international standards must work not after disputes end, but before livelihoods collapse. Therefore, where evidence is complete, immediate advance payment is appropriate, and where uncertainty remains, a first-stage payment using statistical estimation and standardized unit prices followed by additive settlement upon additional evidence is a rational structure. Third, funding must be separated into a special account or fund to secure sustainability. There is no need to deny that the developmental state of the 1960s-70s built national competitiveness through infrastructure investment. However, if victim rights were not sufficiently settled in that process, the unsettled portion must be placed back on the national ledger as a moral and operational liability and repaid. The reason compounding widens the gap is the time value of money, and reasonable public benchmarks include inflation, indexing, government bond yield indexing, or nominal growth rate indexing. Fourth, a special measure is needed to reopen closed application windows. The 2014 deadline is an endpoint of administrative convenience, not an endpoint of justice. For survivors newly identifiable through national records or bereaved families who previously lacked access, a time-limited special law permitting reapplication is the minimum of coherence. What Professor Nam Yong Lee, the son of Oksun Lee, should do now to actually receive compensation is as follows. First, he must search for and confirm the record of Oksun Lee in the National Archives, producing a record verification packet in the form of printed extracts or certified access documentation. This step is not emotion but identification. Second, he must assemble an heir status packet, including a family relationship certificate, a deregistered family register, a death certificate or proof of death, and documents relating to origin and birth. Only when the record verification packet and heir status packet are combined do administrative bodies and courts move. Third, he must submit a formal inquiry to the relevant government support unit centred on three questions: whether there was any prior determination, whether any reserved amount exists, and whether redeliberation is possible. This unit states that it manages payments such as condolence money, analyses related records and handles petitions, and it discloses its contact information. Fourth, he must check the annual bereaved family welfare support notices of the supporting foundation for victims of forced mobilization and apply immediately if he meets the criteria. Even if this route is not identical to court-awarded money, it is a realistic instrument connecting official recognition and support. Fifth, the civil litigation track must be chosen not by possibility, but by purpose. Claims against Japanese companies face enforcement difficulties even after judgment, and policy approaches such as third-party payment remain socially controversial. However, there have been recent reports of money being paid through a Japanese company's deposit with a court. Therefore, whether the Oksun Lee case can establish causation with a specific company and what must be secured domestically first should be evaluated soberly with counsel. This is not a matter of ethnic sentiment, but of restoring the national ledger and responsibility. If victims can be identified through national records and yet settlement cannot be completed, the state effectively confesses that it is an operating system that failed to design responsibility. The funds used in the name of growth and the unresolved rights left to victims must now be reconnected as a national settlement project. Korea now says it has become an advanced country. The condition of an advanced country is not the height of buildings, but the precision of a system in which the rights of the weak do not disappear from the ledger. The issue of victims of forced mobilization is not a past event, but a living benchmark that tests the quality of national governance today. Thank you for watching Professor Nam Yong Lee's column, Long.